You are at the panel, two legal guys discussing regulation of cryptocurrencies and digital coins. And this legal guy, his name is Gary DeWall. I'm special counsel with Catton Mucci and Rosenman here in New York City. I help the firm in connection with matters related to the crypto space and digital coins. And I've been around for quite some time. Lee?
I'm the other legal guy. I'm Lee Schneider. I work at McDermott, Will & Emery. I'm a financial services and technology lawyer and have been for 25 years. I don't know if Gary beats that or not. I think we're...
I beat it. Sorry.
All right. Well, that's okay. Anyway, we're here to chat amongst ourselves, but we definitely want you guys to ask us questions because Gary and I know each other really well, and we already know what each other's going to say, and we don't know what you're going to ask us. So
right. So
please.
Think of this as our living room, and you are those guests at Thanksgiving, which you're going to try to endear yourself to us. So you really, if you want a slice of turkey, you got to speak up. Don't hesitate.
Or a glass of wine.
Or a glass of wine. There you go.
Give them some real inducement.
All right. So let's go right to the meat of the discussion. It's been regulatorily, it's been challenging to pick up the newspapers the last couple of days. There's 3 class actions in the ICO space. You've got a crypto unit at the SEC and all sorts of mutterings from the SEC related to ICOs, maybe securities. You've got international regulators issuing warnings to 2 countries prohibiting them. What's going on in the space right now? What can you advise us? How do we do it right?
So there's no easy answer to that question, but look.
Give him a chance, for God's sake. He'll get there.
So if I came to a programmer and asked them to program something for me, I think I get the same answer as I just gave you. So look, there's a lot going on. And what we try to tell our clients who are in the crypto space is they got to really keep track of 3 main things. 3 things to keep your eye on. The first thing to keep your eye on is what is the nature of the token? That sounds like it's an easy question, but because tokens are a digital representation of an asset, it can mean that a token could be anything. So you could have a token representing an ounce of gold, you could have a token representing a share of stock, you could have a token representing somebody's identity, you could have a token representing healthcare records. I could go on and on and on. So it's really important, whether you're an investor, a regulator, a creator, a lawyer, an accountant, understand what is the nature of the token that you're dealing with, what are its functions and features, what's the nature of the blockchain project, what are its functions and features. That will help you gain a lot of insight. The second thing we tell everybody to keep their eye on is the tax treatment. Many people forget that, or I should say it differently, many people think that because we're dealing in the cryptocurrency world, somehow taxes are not relevant. And the IRS takes a completely different view, which should be unsurprising to no one. So definitely want to make sure you understand what the tax implications are of whatever it is that you're planning to do. Again, whether you're an investor, creator, or whatever. And then the third thing to keep your eye on is, and I'm a securities lawyer, so I look at it from that perspective. In a minute, Gary's going to look at it from another perspective. But the third thing to keep your eye on is whether or not the token is a security, because that is one key issue about how you can go about selling it. So, Gary.
Wait, no, don't go away yet.
No?
So talk about, just to clarify, do you have a different view on the simple agreement for future tokens versus ICOs? What's your thinking? Is it safe to be involved in a pre-sale? Is it safe to be involved in an ICO? What's your thoughts on that?
The short answer is yes, it is safe. The longer answer is it depends on how the token seller is structuring their sale. It gets back to what is the nature of the token that's involved. It gets back to the questions around taxation and the securities law questions. There are not always easy answers. Some people are doing really interesting creative things that are very challenging from a regulatory analysis standpoint. But look, we have clients who are doing token launches now. We have clients who are buying tokens. Some people are using the SAFT, the SAFT that the Cooley law firm proposed. We don't necessarily think that the analysis, the analytical framework that they came up with is the right analytical framework. I've expressed in a number of venues some disagreement with that framework, but it's an important framework that's out there, and people need to be grappling with it.
Yeah, I think one thing that's really, really important, I mean, we're both versed in traditional securities, and I've got my big background is derivatives. But, one common denominator, as this industry becomes more mature, the disclosures are evolving in a better way. Even if folks are taking a view that these are not securities, I think that the disclosures are getting more comprehensive. The bottom line is, if I'm an investor and I'm picking up a white paper and it sounds great, but I have no idea what they're talking about, probably wouldn't get involved in that, okay? I mean, we see it from SEC enforcement actions. We see it from Securities and Exchange Commission. We see it from Commodity Futures Trading Commission enforcement actions. There are guys out there who are promising a lot right now, and they're delivering nothing, at least according to the allegations of enforcement actions that are being brought by federal regulators. And so it's really important that when you're looking at something, even if it's being hyped by third parties in the social media world, I hate to use the word, but hype could be fake news. Okay, it's really important that you, the investor, understand what's going on, and if you don't understand, and there's a contact number, use that contact number to follow up. And if someone is willing to explain something to you, and it makes it clearer, that's not a bad thing. Okay, if someone talks to you and you're more confused, not a good thing. Not a good thing.
And I completely agree with you, Gary. And I think one of the reasons that the disclosure is getting better is because more lawyers are getting involved and trying to make people give better disclosure. One thing that I tell my ICO clients, and by the way, I hate the term ICO, but it's become so prevalent that I will use it. One of the things I tell all of my ICO clients is don't commit fraud. It's a pretty easy thing to say. It's a pretty easy thing to remember. And that means that you have to have good disclosures. People want to understand what it is that they might be buying. People want to understand what the functionality of the blockchain and the token are going to be. People are going to want to understand what your timelines are, how many tokens are being sold. All of these things are points of data that investors use when they make determinations about this stuff. So, Gary, you asked me a whole bunch of questions, so I get to ask you a question
You
now.
get to ask me at least one question.
All right.
Fair enough.
So you and I sat on a panel at the beginning of September where you defined commodity as to be virtually everything in the world, including me.
Including you, including Lee Schneider. Mm-hmm.
To which I responded, I believe I have 2 teenage daughters, and I am definitely a commodity on that basis.
That is correct. You did.
But so please give everybody the definition of commodity. Don't forget the onion exception.
and the movie rights. The CFTC actually has been in this space. The Commodity Futures Trading Commission, which is the regulator of futures and most swaps in the United States, has actually been the most active regulator in this space. They asserted jurisdiction over the cryptocurrency space to the extent it involves derivatives, and I'll get into what that means in a second. But to the extent they involve derivatives, they've asserted jurisdiction, going back a couple of years now, and they've actually brought a whole bunch of enforcement actions because the CFTC, it all starts with a definition of a commodity. And definition of a commodity is basically the stuff that you saw in trading. Everybody saw Trading Places, or most people saw Trading Places, right? So you remember Eddie Murphy sitting there with some gold, some bacon in front of him. Those are the easy commodities to understand. But commodities is also defined to include all other goods and articles, which is just about everything. Moreover, it's rights and interests in anything that might become a futures contract in the future. Which is pretty great because today, if you can show that 20 years from now something became a futures contract, it's a commodity under the Commodity Exchange Act as of today, which is pretty cool. Which is pretty cool when you think about it. Well, that's just the starting point. That's just the starting point. The CFTC has 2 jurisdictions over commodities. One is exclusive jurisdiction, which I believe is going to be something that people like and are going to try to get under going forward. And they have exclusive jurisdiction if effectively there's futurity involved with that commodity. So if there's a futures contract, something looks like a futures contract, so it's standardized, it's got some leverage embedded in it, or it's a swap which is just another fancy type of futures contract, then the CFTC has exclusive jurisdiction if that product trades on an exchange that it regulates. Now, what that means is no states are involved. There's no bit license. There's nothing like that. Nobody else can get involved if the CFTC has exclusive jurisdiction. And this is one of the reasons why one exchange, LedgerX, applied and got status as a swap execution facility and a clearinghouse under the CFTC, because that basically blocks all other regulators in the United States, including the SEC, from touching what goes on that exchange. The CFTC's got another interesting authority, and this is something that I think people are going to, unfortunately, become aware of more and more going forward. As a result of Dodd-Frank, as well as some historical provisions, the CFTC also has jurisdiction over anything that constitutes a manipulation of a commodity or fraud or deceptive device in connection with the offer and sale of a commodity.
Don't commit fraud. Remember, I said that.
Don't commit fraud. That's critical. And where that becomes very, very relevant, it means, for an example, if someone committed manipulation today on, let's just pick any one of the Bitcoin exchanges, and I don't mean to pick them for any, because I know anything, it's just that their name comes to mind because I love their name, Kraken, okay? The big monster with lots of arms. If someone commits manipulation on that exchange today, the CFTC could go after that person today, okay? Even though Kraken has nothing to do with being under CFTC oversight. That's pretty powerful. And they used that authority a couple of months ago in a case involving a company known as Government Blueprint, which effectively was running a Ponzi scheme. And when people saw that, and they said, wait, there's no reference to derivatives here. What does this have to do with the CFTC? People went, whoa, okay. And whoa, it should be, because that's pretty broad authority. So the CFTC's got real authority. They also have authority over spot contract sales where they involve financing, and the actual Bitcoin or crypto might not be sold, may not be actually delivered within 28 days. And there's a lot of controversy over what means actual delivery. And in fact, the CFTC will start dealing with that in January formally through something called the Technology Advisory Committee. They're going to try to address that, is my understanding. So that's something to look forward to. But the CFTC is pretty big in this space. And one of the things that bothers me is that because the SEC looks at these things as digital tokens, and the CFTC is looking at them as cryptocurrencies, they're both sort of losing sight of the fact that we're talking about ledger entries. Okay, they're objectifying things, and the objects don't really exist, as we all know. They're just entries on a ledger somewhere, and things change over time. So in fact, if you look at the Ethereum project, probably applying the SEC analysis, the Ether contracts that were initially sold as part of that ICO might have been thought of as securities back when. But today, no one is thinking of Ether as a security. Well, when did it change? Well, when it changed has real implications, because that moves something from SEC and potentially state oversight to the world of potentially CFTC oversight. And that's something that's going to be sorted out going forward, I think. And frankly, at some point, it will be a good thing that that these various fabrics, because now you've got CFTC, SEC, FinCEN, you've got New York Department of Financial Services. Soon you're going to have state agencies because of the virtual currency law. I mean, too many hands in the pot are never a good thing for the development of an asset class. And this regulatory conundrum out there is going to have to be reconciled at some point.
And I agree with everything you said, Gary, and now I'm going to take partial issue with what you said.
Okay, fair enough.
Which is, and this gets back to the first point that I made, which is the nature of the token is hugely important here. It may be that a commodity is everything except certain movie rights and certain types of onions.
No, not certain types of onions. All onions.
All onions.
All onions.
Okay.
They're excluded from the definition of a commodity.
All right. Does that include green onions? Or
green onions, scallions.
Yep.
You betcha.
Okay.
Shallots, probably.
Okay. I've got a little reading up on my onions to do.
There
apparently.
you go. Uh-huh.
But look, the flexibility that the tokenization process affords people allows them to be really creative with what these ledger entries are about. In other words, what these are transactions in. What's the asset here? And some of these assets are natively digital assets like Bitcoin, but other of these assets run the gamut of things that you and I haven't even thought of yet. I'm working with projects that are looking at tokenizing healthcare records and tokenizing identity, and you just keep running down the list, and many of those things have not traditionally been thought of as commodities, although perhaps the definition of commodity is broad enough. And many of those things have not been traditionally considered in the securities context. But what's happening is people are seeing liquidity as a substitute for whether or not something is within the definition of commodity or security.
Right.
And this idea that, well, just because something is liquid, just because there's a liquid market for something, it takes on this character of a financial instrument is something that I am starting to fight against. And I've started talking and writing a little bit about a concept that I call contextual regulation. You can't divorce
I have to say, that sounds really sexy. I like that. I like that phrase.
You can't divorce the regulation of the thing from what it is just because you've digitized it. And so in the healthcare space, if you're digitizing healthcare records, you got to worry about HIPAA. You can't, it's not just a question of, well, is this thing a security? Is this thing a commodity, et cetera, et cetera? You got to be thinking more broadly from a regulatory standpoint. Sure. I don't think the regulators are doing that yet. They're not there.
But
and we got to drag them in that direction.
I come from an industry, so I hate to say that I was once young, but in fact I once was young. I grew up in the derivative space at a time when the SEC and the CFTC would basically have proxy litigation in court. Over who had jurisdiction over products. And that was pretty prevalent and the states were involved too, by the way. The states also tried to get to the space and try to have jurisdiction. And there were lawsuits left and right. If you talk about a waste of taxpayer money, there it is. But ultimately, the smart people sat around the table, they figured things out, and they went to Congress and they passed a law. And in fact, today, we have very good definitions of what constitutes a security, what constitutes the futures. There's black and white lines that can be identified. Sometimes it's a little difficult to know real time when you might have crossed that line, but overall, there's a framework. There will have to be developed that kind of framework here so that we know what we're talking about.
But we can't just treat it as a homogeneous asset class because it may not be a homogeneous asset class. And we can't just say that blockchain is an industry because blockchain is a technology that gets implemented in industries. It's not, I think, an industry unto itself.
The other interesting is it's going to be very challenging from a global perspective to also rationalize this process, and that's going to be very critical. Obviously, the whole concept of a decentralized ledger is that it's all over the place, and the problem is if the points of entry or the rules around the points of entry are different in different places around the world, you're going to have inefficiencies that will benefit some people and obviously harm others, and that's going to have to be dealt with also. You cannot have a system where there's going to be such inefficiencies, but you do have different laws, different politics that come into place. ICOs were banned in China, yet they shut down the cryptos exchanges. That was a political statement. That's just the reality of life.
I think that's right. And one other piece that I like to talk about for contextual regulation is the country context too. It's not just the industry context, but it's the country context. The problem is, as you correctly identified, with decentralization, is that there is no one country that it's located in, and you can't say, well, for when I'm acting on the Bitcoin blockchain and I'm located in China, X rules apply, but when I'm located in the U.S., Y rules apply, because it's just all pre-programmed into the system.
I'm a simple guy. I want it to be homogeneous when I'm in New York versus when I'm in Iowa. I want the same rules to apply. Okay,
yes,
seriously. I'm a simple guy.
How dare you want to trade on a Bitcoin exchange in New York?
In New York, exactly, exactly.
Yeah. No. Look, I think let me ask you another question, which is what I'm starting to see from clients is, hey, how can we have exchanges that will trade tokens that are securities? Can you talk a little bit? Are you seeing the same thing on
I
the
am seeing
commodities
that,
and
and I
derivatives
think
side?
that's why people are very interested in seeing what Overstock is doing next, because Overstock is trying to come up with, we call it an automated trading system, but alternative trading system, but in fact it is an exchange, and they are proposing to have an exchange to list digitized securities and
yep.
potentially securities issued through ICOs. And I think the success of Overstock's recent stock price demonstrate that there's a great interest in what they're doing. Listen,
Now, could you take, so let's not overstock it, let's decentralize it, but could you create an exchange that would both be a SEF and under the CFTC's jurisdiction and an ATS under the SEC's jurisdiction in the same legal entity?
you know, if you can't currently, I mean, there's no, let me take that back. There is no reason legally why an entity couldn't have multiple regulations
Licenses.
other than the fact that the regulators are disorganized, and complying with two sets of rules would be very difficult
In the same entity,
you always would have to conform to the most difficult. Already today, there are clearing organizations. OCC is one of them, Options Clearing Corp. And they are subject to both the oversight of the CFTC and the SEC, being a clearinghouse both for options that are traded in the securities world, and they've got they do futures trading also. And it's tough because they've got to comply with the most difficult of the two rules all the time. But I do think that the smart folks currently in DC will figure this one out. I have experience. I was involved with the approval process of LedgerX, which had, as I said, had authorization as both a swap execution facility and a clearing organization. And by the time we had gotten involved, LedgerX was well in their process. I like to think we helped a little bit push it across the finish line. But I could see the wheels turning at the CFTC. I could see they were open to ideas. They had never dealt with an exchange or a clearing organization where when you walk into an office, there wasn't file cabinets.
Right.
That was a big thing.
Right.
The fact that storage is in the cloud, the fact that records are kept on a blockchain. They had to get comfortable with that. Or at least be willing not to impede the development of the technology. And I give the CFTC a lot of credit. And clearly right now they're evaluating two new contracts. They're evaluating the CME's contract on a Bitcoin index, and they're evaluating CBOE's contract based on Bitcoin. And there are different issues. By the way, just for clarification, they are different products. LedgerX actually is a product that results in settlement in Bitcoin.
Physical
Effectively
physical settlement.
Virtually physical settlement. Where CME and CBOE are proposing cash-settled contracts. There are different issues. And one of the important things is for the CFTC to recognize that the different issues are out there and to make sure that they evaluate them, put the right restrictions, whatever they want, or encouragements on it that they need. But they need to look at things differently. This goes to your point before. Not everything is the same. They have to be looked at differently. Just because it uses the word Bitcoin doesn't mean it's identical.
And one of the great things about what LedgerX is doing, what CBOE and CME are doing, is that hopefully it will help the development of the trading in the Bitcoin itself as a particular asset. One of the things that the SEC said when it denied the applications for ETFs
BZX.
Earlier this year is that that the markets were too underdeveloped in Bitcoin right now, and they pointed to the fact that there were not futures, options, and other types of derivatives markets for Bitcoin yet, because I think they view those markets as helping to stabilize volatility of prices. So by all of these efforts on the commodities, on the CFTC regulated side of the world, hopefully that will bring things closer on the SEC side of the world and we may have a Bitcoin ETF or some other similar.
Well, yeah,
type
I mean,
of,
there are a number of issues that have to be sorted out. At one point, the SEC is going to have to deal with custody on the Investment Company Act, on the Investment Advisors Act. They're going to have to deal with the concept of what these products are. Are they funds? Are they securities? Because those have implications as to how an investment advisor can deal with this. There are definitional issues that just have to be unified. And by the way, one thing I do want to mention, one of the interesting aspects of these court cases coming out, and again, this is geeky lawyer interest. Human beings don't have interest in this kind of stuff. But a lot of the developments are going to be random. You've got 3 class actions, which will ultimately be consolidated into 1 class action. And unless the thing is settled, you will get a decision, whether it's even a motion to dismiss, meaning the case can be gotten rid of at an early stage. Okay, you've got this Gelfand blueprint case, which I've told you, where the defendant has actually challenged the CFTC's jurisdiction. Okay, courts will have a say on this. Okay, and their say will actually be pretty critical in the development of law in this space.
Yeah, I agree with that. The other thing I'd say is, and I think you've had the same experience with the CFTC, when I've spoken with the SEC about these issues, they are hungry to learn.
Right.
They have a group within the SEC that's not just within the enforcement division. They have people across various divisions of the SEC that really want information, and they are very much doing research and trying to understand how these markets work, whether or not they should be regulating, if they should be regulating, what should they be regulating. We don't have any answers yet, but at least we know that they're trying to find those answers.
Okay, we've managed to converse about 2 minutes. Okay, good. A first question. I don't know whether they need a mic or something. We can repeat whatever.
I can yell.
Okay, yell.
So you mentioned at the beginning that you were skeptical of the Cooley SAP framework. Can you elaborate on what your concerns or problems are with that framework?
Yeah, so first of all, I think it's an excellent effort that they put out there, and I want to be clear about that, okay? The issue that I take with their analysis, the main issue that I take with their analysis is that they make this distinction between pre-functional and functional tokens as if that bright line solves everything from a Howey test perspective. And I just don't think it does. I think it's really a facts and circumstances test. You know, if you drew that bright line, then you might say that everything on Kickstarter, which is mostly pre-functional, needs to be regulated as a security. And there are arguments about whether or not something is consumption/commercial versus investment. But as I said earlier, we really have to grapple with what we mean by investment, because if you look at what's going on in the CFTC world, all of those things are investments too, and nobody's saying that they are.
Yeah, that's what I struggle with, because literally the value in most of and a lot of these tokens is the turnover, is a network effect in the marketplace.
Exactly right.
And that's very challenging.
And if that's how you derive your securities law analysis, in other words, if there is secondary market trading in something and that makes it a security, I think that's way overbroad. I still have some of my baseball cards from when I was a kid. Apparently I drew all over Pete Rose because I didn't like him as a player, which probably was a bad thing. But look, I still have those.
By the way, your baseball cards are commodities.
Right? But I'm not going to enter into a futures contract or a swap about them. But I could go to a baseball card shop and try to sell them. I could try to sell them on eBay. There is a liquid market for baseball cards. There are people who collect them and want to buy them. There's a liquid market for all different kinds of things that nobody says is a security. They may be commodities. You may have to talk with Gary and his buddies, but you don't have to talk with me and my buddies, right? And so we really need to be focused on this concept of, hey, what is the thing that we're talking about that's being tokenized? Because to my mind, that is what determines whether or not something is a security.
So I think we have time for one last question. Go ahead. You're in the bright lights there, so we can barely see you.
We can't see you.
I saw a hand waving.
Yeah, so I've been telling people that I think that if you put a hard cap on the number of tokens you're going to issue, you're making a claim about expectation of profit about scarcity, and you created a security token. A hard cap is fundamentally not compatible.
So you're saying Bitcoin then is a security?
I'm saying that if you issue Bitcoin now as an issuer, you'd be issuing a security.
I mean, to me, it's almost the exact opposite. And I mean, I'd like to hear more. We don't have time. I mean, to me, it's almost the exact opposite because it's the limitation that, in fact, powers the value of this thing potentially as a currency out in the real world. I think that it's the scarcity that's driving Bitcoin's price right now. People know there's only going to be 21 million of these things, out there. I don't think any one quality is going to make a thing a security or not a security. I think you've got to look at a bunch of different items. If you go online and you Google what drives the price of cryptocurrencies, and I've done that a couple of times, you get some very interesting articles online, and very few of them actually talk about tying it to the price of the underlying project. Very few of them tie the value of those coins to the underlying project, which I found fascinating.
So I agree with Gary. I think it's an interesting concept that you're putting out there, but again, you need to think about the limitations that it's imposing on the analysis if that's sort of the silver bullet for determining whether or not something is a security. So you do need to do a real facts and circumstances analysis, I think. Maybe let me just add one more point to follow on what you just said, which is, to me, one of the fascinating things is that when you look at CoinMarketCap or one of these other consolidators that shows you market capitalization, quote unquote, which again, it's not really market capitalization. You see that it's really protocol layer tokens rather than app layer tokens that have the high market caps, that have the high value. And that's sort of different than the way you see the rest of the technology world right now. And so very interesting to keep an eye on when will app tokens, if ever, overtake protocol tokens in terms of valuation.
Okay, we're out of time. If you have questions, we'll hang out a little bit, but otherwise enjoy the conference and good luck.
Thank you all very much.